Hello everyone and welcome. Thank you so much for joining us. My name is Anya and I am with Stop Climate Chaos, and this is the first of our autumn series of campaigning and webinars. And it's great to start the series and the season with something good. We don't often have good news to report on climate change, but it's very important to celebrate it when we do. And as many of you may know, on the 31st of July, the Supreme Court found unanimously in favour of the environmental organisation Friends of the Irish Environment, who are a member of Stop Climate Chaos, and they quashed the 2017 National Mitigation Plan, which many people, including ourselves, have criticised as weak and unambitious. And Ireland is one of only 2 countries in Europe to see a successful challenge to government climate policy in the courts. So it's really great to have a win like this under our belts, and congratulations to Friends of the Irish Environment. So the Supreme Court did not find that Friends of the Irish Environment was entitled to argue that environmental rights had been violated, but the judgment is regarded as a turning point for climate governance in Ireland. And we're absolutely delighted to be joined by Dr. Andrew Jackson this evening. Andrew is a lecturer at the UCD Sutherland School of Law and was a member of the Friends of the Irish Environment legal team. And he's here to help us tease out the implications of the landmark judgment. And then in conversation with Andrew is Sadhbh O'Neill, who is the Stop Climate Chaos Policy Coordinator, but who also contributed to the climate case as its campaign coordinator when the case launched in 2018. So we're absolutely delighted and very excited to be able to have this conversation, to learn about the case itself, and also to look forward to see what does it mean for climate campaigning in 2020 and beyond. Some technical things. Please feel free to have discussions in the chat box. Make sure that when you're talking in the chat box, you have selected to all panelists and attendees, not just all panelists. And if you want to ask questions to Andrew or Sadhbh, please use the Q&A box. So please only use the Q&A box for questions to the panelists. And what you can do in the Q&A box as well is we've enabled it so that you can upvote other people's questions. So if you see a question that you really want answered, or it's a question that you had yourself, but someone has already answered it, can you just make sure that there's a little arrow beside each question and you can upvote the questions. And the ones that rise to the top are the ones that will get answered first. So yeah, but in the chat box, please feel free to have discussions and comments, and we'll be monitoring that. So I will hand over to Sadhbh and Andrew. Andrew's going to give us a presentation first. So yeah, take it away, Andrew. Thank you so much for being with us.
You ready to kick off there, Andrew? Brilliant.
I am. I was just sharing my screen. Shall I just go ahead, Sadhbh?
Yes, please do. Yeah, we're dying to hear what you have to say.
Okay, well, thanks everyone for tuning in. For those who, I know a few of you may have seen a webinar that I spoke on last week about this case. Some of this material will be familiar, but there is, fear not, a bunch of additional and different points here specific to the Irish contexts. So I hope there'll be something of interest to everyone. So Climate Case Ireland then, the first thing I wanted to do was to give a bit of context to the case. So if you turn the clock back to 2017 when the case launched, Ireland was doing very badly in terms of climate action, with the 3rd highest greenhouse gas emissions per capita in the European Union, with the projections showing that emissions were going to rise and not fall. And crucially, at that time, the government was perceived to be playing a negative role on the international stage, trying to dampen ambitions for EU action out to 2030 and beyond. And so all of those things combined led us to think, well, how could the law be used potentially to change the story here and to maybe force a change of direction? The opportunity, or the legal opportunity, arose when Ireland adopted its first domestic framework climate act in 2015. And as you will know, under the Climate Act, the government has to adopt a National Mitigation Plan every 5 years, with the first one to be made by mid-2017. And when that document emerged, first in draft for a brief public consultation, and then in its final version, it was, lo and behold, very weak, very vague, aspirational, and so on. The way that judicial review works, we had just 3 months from the date of adoption of the plan to lodge a legal challenge. So we set to thinking about, well, what's the strongest case that we can put together? And in discussion with John Kenny, Junior Counsel, who I see has tuned in today, we began sort of thrashing out ideas for a case. And our sense at that time was very much, look, someone has to do this. Like, somebody has to challenge this National Mitigation Plan. If it's not challenged, potentially it will be another 5 years before there is an opportunity. And as you all know, 5 years is a long time in terms of lost climate action. So we went about designing the case, and it launched in October 2017 when we were granted leave to proceed by the High Court. And subsequently, we had judgment from the High Court in September 2019, and recently judgment from the Supreme Court in July this year. The essence of the case, you could break it down into 3 broad groups of arguments. It was a legal challenge to the 2017 National Mitigation Plan, essentially alleging that the government's decision to adopt the plan didn't comply with the Act. So that was one bundle of arguments. Breached the Constitution, in particular the right to life, the right to bodily integrity, and the unenumerated or unwritten right to an environment. And it's important to say, at this time when we launched the case, no such right had been recognised by the High Court. So this was a fairly speculative argument when the case launched. And the third group of arguments allege that the decision to adopt the plan breached human rights law, in particular the European Convention on Human Rights, the ECHR, the right to life, and the right to respect for private and family life and home. These are issues that had already been litigated at first instance in the Netherlands by Urgenda. But again, when the case launched, there had been no finding by the Dutch courts of a direct infringement of the ECHR. So again, we put forward this line of argument thinking, well, Urgenda will probably, is going to be appealed, and so potentially there'll be a different outcome on appeal. But also, we could run the same arguments in Ireland and see the conclusion that the Irish court comes to. Perhaps that would be different from the Dutch court. So the case was, it was directly inspired by the Urgenda litigation. And we built the case very deliberately, as had Urgenda, on the science of the Intergovernmental Panel on Climate Change and on other, effectively uncontestable sources of evidence. And this is a really important part of the case that it's important to emphasize, because had we gone into the High Court using other science, the case would have been thrown out. We would not have been successful, because the High Court would have said the government has relied on the science, the scientific advice that it receives. You're coming in here citing other science, maybe science that says there needs to be more ambitious action. I, the High Court judge, am not a scientist. I'm a judge. The government is entitled to, a kind of a broad margin in reaching its decisions. It has discretion, and I'm not going to intervene. So what we did instead was to use the IPCC science, which had been endorsed line by the government, such that we could go into court and say, look, here is the science, which is agreed. Here are the impacts, which are agreed. And what we're discussing now is what are the legal consequences that flow from this agreed evidence. So that was the basis of the case. And that is an approach that worked, because the government did not contest at any point our presentation of the science or the underlying science itself. They accepted it and the impacts. So after the case launched in October 2017, there were 2 important legal developments which served to increase the prominence of the rights aspects of the case, so the Constitution and the ECHR aspects of the case. The first was another judgment of the High Court in a different Friends of the Irish Environment case related to Dublin Airport. And the judgment was handed down in November 2017, so just a month after Climate Case Ireland had launched. And Friends of the Irish Environment lost on the substance of the case in that they did not succeed in preventing the permission for the runway, but the judge in the case nevertheless went for one of the arguments the Friends of the Irish Environment had made, which was there is an unenumerated or unwritten right to an environment in the Constitution. And you can see the text in full there in green, a right to an environment consistent with human dignity. But the Irish government didn't accept that this was a binding finding of the High Court and continued to argue in our case, in Climate Case Ireland, that this was just a so-called obiter dictum and that no such constitutional right exists. So they continued to contest the right, but nevertheless, as you can imagine, this finding increased the strength and the weight of precedent behind the arguments that we made around an unenumerated right to an environment in Climate Case Ireland. The second important development was the decision of the Court of Appeal in the Urgenda case in October 2018, which the Court of Appeal, in contrast to the first instance court in Urgenda, the District Court, found that there had been a direct breach of the European Convention on Human Rights. And again, that served to strengthen the argument that we were making in respect of the ECHR and Climate Case Ireland, because now we had an international precedent to point to, a decision of an appellate court in Europe finding a direct breach of human rights in respect of a country failing to follow a science-based emissions reduction trajectory. So Urgenda went from being an inspiration for the case to being potentially a very powerful precedent for the case. Just a couple of things about how we presented the science in the case. So we had two essential principles. The first was present the science as clearly as possible, because we had a very real sense that the facts were very strongly on our side, even more strongly on our side than was the case for Urgenda in the Netherlands, because the Dutch government was reducing its emissions, but not by enough. In contrast, the Irish government was allowing emissions to continue rising. So we wanted to present the science very, very clearly, and I think we succeeded in that regard with a strong kind of uncontested narrative in writing before the court. And we also put a lot of thought into, well, how do you actually explain, some quite difficult climate science to a judge who may not have background in the area. So we produced, we pared down the evidence, the exhibits, to a single lever arch folder, a core book, and we blew up about 20 images to A3 size in colour, allowing counsel to speak the judge through the science of climate change with a clear narrative and with very clear figures before him in the High Court. And the second principle was then we want to present the science in a way that would resonate with and align with the Urgenda judgments, because we wanted to say that the Urgenda judgments are a strong precedent for our case. But in order to do that, you have to present the science in the same way that the science is presented in the Urgenda judgments. And I can explain very briefly what I mean by that, which was, don't worry too much about the detail here. The blue line is just Ireland's emissions, actual and projected, the blue line, and you can see that they're quite high there. And the science that Urgenda argued in its cases, or in its case before the various courts and in Climate Case Ireland, is represented by the pink and the green lines here. And that shows a reduction between 1990 and 2020 of between 25 and 40%, which would give a chance of limiting warming to 2 degrees Celsius. And so we were able to, in presenting that science and saying the Irish government has endorsed that reduction range, but lo and behold, here's what they're actually going to do with the blue line, we were able to say to the court, well, look at the gap between what the government says it needs to do and what it's actually planning to do. And in those circumstances, we argued there are infringements of rights and the government was not complying with the Climate Act. And you can also see the steeper reduction trajectory for 1.5 degrees, represented by the yellow line at the end, and the continuing gap between what's projected to happen in Ireland. In parallel to the legal argumentation, we had a sense, with advice from Urgenda and others, that it was going to be important to run a public campaign alongside the case in a way that is not common, I suppose, in environmental litigation in Ireland. And there are various images you can see from that campaign here, a campaign which really was quite incredible and grassroots, with Sadhbh and Clodagh, leading the charge there. We went from the early days of the case, when small numbers of people were coming along to court, with we had support from Patagonia, who gave small grants to pay for some campaign hours, who held events in their shop, who decorated their shop front in Dublin, as you can see here. Support from the Climate Litigation Network, which is an initiative of Urgenda, and support from so many countless amazing volunteers, who really together helped to build an amazing campaign. And we went from this small seeds of a campaign to, via our website, which allowed members of the public to sign up in support and to say that the case would be in their name, to more than 20,000 supporters. By the time we got to the High Court hearing, I think more than 17,000 had signed in support. And the experience of the High Court, and I know some of you were there, was really quite incredible. And this quote from Eamon Ryan, I think, who was there on the final day, captures it really well. He said, "I've never seen anything like it. Babies and toddlers, young and old, spread politely on the court floor, rapt in attention to the proceedings. It would make you proud of our republic." And it really would. It was a really moving experience to be present for the hearing, to hear fundamental rights like the right to life being aired and litigated in front of all of Irish life, from the very youngest to the very oldest. And I've described before how on the final afternoon, the council's voices were competing with several babies and toddlers' voices in the room. The judge at one point had to stop the proceedings to find some space on the floor for people filing in. He had to say, well, there's some space down beside my desk and you can come and sit on the floor down beside me. Really, really an incredibly powerful and, as I said, moving experience. But we went from that, the sort of the high of the hearing, to the low of the judgment when it came from the High Court. And what we got was a deferential decision from the High Court. The court relied on the separation of powers, essentially allowed broad discretion to the government in formulating what the government characterised as policy. This is policy, the court is not going to intervene. Regarding the constitutional and human rights aspects of the case, the High Court said the Friends of the Irish Environment did have standing to litigate those issues, but that it couldn't be concluded that it's the National Mitigation Plan which places the rights in question at risk. And in addition, the High Court put in place an additional hurdle, which was to say, based on domestic Irish case law, that anyway it wouldn't be for the domestic court to declare rights under the ECHR in respect of climate change, but rather we should wait first for the European Court in Strasbourg to give a judgment on climate change. In other words, the domestic courts shouldn't jump first. Friends of the Irish Environment was then granted permission to leapfrog its appeal, so to jump over the Court of Appeal and go directly to the Supreme Court. Then COVID intervened, of course, and initially the Supreme Court, we had some procedural hearings virtually, and originally the hearing was to be held virtually, but the Supreme Court decided in the end that we would proceed in person, and you can see ourselves arriving here to the Supreme Court, which was held uniquely in the dining hall of the King's Inns, with the court sitting in a 7-judge formation, which is the exceptional formation that is used for cases of particular importance or complexity. And the reason for this unusual venue, of course, was to allow for social distancing of the 7 judges and legal teams and a small number of public observers, in contrast to the High Court, where the court was packed. So the Supreme Court's judgment came exceptionally quickly, just 1 month between hearing and judgment. And normally the Supreme Court is running at about, on average, 12 to 15 months to give its judgment from the time of granting leave. So this was very, very fast. We got a unanimous judgment delivered by the Chief Justice. And 3 points to emphasise. First, the plan falls well short of the requirements of the Climate Act, and so had to be quashed, and a new plan is now needed. In respect of the rights aspects of the case, the court said, as a corporate body, because Friends of the Irish Environment is a company, it's a charity, it doesn't enjoy standing to litigate the rights, the personal rights aspects of the case, because a company doesn't itself enjoy those rights, the court said. And third, the court expressed the view that there's no unenumerated or derived constitutional right to a healthy environment in Ireland's constitution. The court said either that right is superfluous, if it doesn't extend beyond a right from which it's derived, like the right to life. If it's not wider than the right to life, then it's superfluous. And if it is broader than one of those extant constitutional rights, well then, the court said, the right as expressed is excessively vague. The central basis for our winning the case was Section 4(2)A of the Climate Act. And there was no issue with standing for this aspect of the case. So Friends of the Irish Environment and the state conceded this was entitled to litigate these arguments. And this provision says a National Mitigation Plan shall specify the manner in which it's proposed to achieve the national transition objective, which is transition to a low carbon, climate resilient and environmentally sustainable economy by the end of the year 2050. And to my mind, the pivotal moment in the hearing in the Supreme Court came at the end of the first day, when one of our senior counsel, Owen McCulloch, took the court to this image from the National Mitigation Plan. And it shows for certain sectors, electricity, built environment and transport, projected emissions, which are shown by the coloured bars out to 2035, and then what would be needed in terms of an emissions reduction trajectory to get down to minus 80% by 2050, which was the national policy position. And the judges looked at this and they said, how does this in any way specify the manner in which you're going to achieve this objective? All you've done here is specify the predicament that we're in. You said, well, look at what's going to happen out to 2035. And yes, there's a cliff edge. There's a massive precipice from 2035 to 2050, but that's what we have to do. And the judges simply were not convinced. I think that was a really important moment when they realized actually this plan, doesn't say how they're going to do this. It just says, well, here's the problem. One point I wanted to touch on, because I get asked about this a bit, was hasn't the 2017 plan been replaced anyway? And therefore, what's the significance of the judgment? Because as you'll know, Ireland made a climate action plan in 2019 and recently submitted its National Energy and Climate Plan to the EU. Those facts do not mean that the 2017 National Mitigation Plan has been replaced, is redundant, or should be read in light of these new plans. The government tried to argue that the 2017 plan shouldn't be overturned because the 2019, because it's a living document, so-called, and the 2019 plan had been made, and the 2017 plan ought to be read in the light of the 2019 developments. That argument was really demolished in the Supreme Court, where it was established quite clearly that the 2019 plan was not a plan under the Act. It's a non-statutory plan. It wasn't made with the public consultation required under the Act. Ministers don't have to have regard to the 2019 plan in exercising their functions and so on. And in terms of the National Energy and Climate Plan, well, that covers a different period, 2021 to 2030, than does the National Mitigation Plan as interpreted by the Supreme Court. So fundamentally, a new statutory national mitigation plan is urgently needed. So implications then of the judgment. First, under the Act itself. So future mitigation plans made under the Act will be reviewed in court on their substance. And that might not sound surprising perhaps to non-lawyers, but Irish judicial review has tended to be narrow and procedural in nature. And therefore, this is quite a significant statement by the Supreme Court, saying it's worth noting that I propose that the plan be quashed on grounds which are substantive rather than purely procedural. And that assessment of the substance is clear from the Supreme Court's judgment, and I've given you a quote here. Having considered what the plan says, it does seem to me to be reasonable to characterize significant parts of the policies as being excessively vague or aspirational. So governments can expect future plans to be assessed on their substance if they get taken to court. Second, future plans must cover the entire period to 2050 and not just the next 5 years. As so the Supreme Court said here, Section 4 requires that the measures necessary to achieve the national transition objective must be specified not only for the first 5 years, but for the full length of the period then unexpired up to 2050. That's a very significant finding. That is different from the government's understanding of what the Act required. They thought they could make a plan for 5 years and then a new one for the next 5 years. The court said, no, you have to make a plan setting out how you plan to achieve the national transition objective right out to 2050. Now that might change over time, but you at least have to say, for example, this is what we're going to do by way of mitigation. This is what we're going to do by way of negative emissions, by way of carbon dioxide removal. And thirdly, and very importantly, the plan must be sufficiently detailed and specific to allow readers to know how it is intended to achieve the national transition objective. Here the court said that the 2017 plan falls a long way short of the sort of specificity which the statute requires. I do not consider that the reasonable and interested observer would know in any sufficient detail how it really is intended under current policy to achieve the national transition objective by 2050 on the basis of the information contained in the plan. So those are three things that future mitigation plans will need to do under the Act. In terms of rights, arguments and standing, important to emphasise first that Friends of the Irish Environment had been held to have standing to litigate rights-based claims by the High Court, both in the Dublin Airport case in 2017 and by the High Court in Climate Case Ireland itself. So I think it's fair to say that we weren't necessarily expecting to lose on this standing point. That said, there had been an unhelpful Supreme Court judgment handed down in 2019 in a case called Mohan, saying that there is no so-called actio popularis in Irish law, no right to sort of take a case on behalf of the public at large. The Supreme Court, in our case, said, as a general rule, a claimant has to be able to show that rights which that claimant enjoyed have potentially been interfered with, and Friends of the Irish Environment as a company didn't enjoy these personal rights. The court said that this general rule can be relaxed in appropriate cases, but decided that this was not such a case. They said an individual could have brought this case, and that a desire to protect individuals from being exposed to, adverse costs of potentially hundreds of thousands of euro was an insufficient reason to offer for why there was not an individual joined to the case. And that, of course, potentially raises issues under the Aarhus Convention. Importantly, the court leaves the door open to future rights-based environmental cases by individuals, and it even indicates areas in which rights may be engaged. And another interesting comment which the court makes is where it refers approvingly to the debate and democratic approval that's involved in inserting new rights by way of amendment of the Constitution. So the court kind of discusses the difficulty of the doctrine of unenumerated rights, and does it just look like judges are making it up and finding rights in the Constitution that they think ought to exist? The court then says approvingly, in many countries which have this constitutional right, that right was inserted by way of a popular mandate, by way of referendum or whatever the process is in the particular country. So that potentially, points the way forward, or one potential way forward in Ireland. And one potential avenue for that might be the forthcoming Citizens' Assembly on biodiversity, which has been promised. Implications. Third thing I wanted to talk about was a plan under the Programme for Government that was recently adopted by the new government, and climate justice considerations that I think are really important to think about now. So as you'll all know, the Programme for Government commits to an average 7% per annum fall in emissions to 2030. And I want to say this really clearly. Emphatically, this does not represent Ireland's equitable contribution to the problem, and therefore does not represent climate justice. If you look back at how this came about, UNEP advised that 7.6% per annum reductions were needed as a global average, assuming massive negative emissions in the second half of this century. So that's the global average. Ireland should be taking a lead. Ireland has benefited from past emissions. Ireland has allowed its emissions to continue to rise, and therefore should be doing much more than 7.6% per annum. Therefore, adopting an average that is lower than that clearly does not represent climate justice. And I would challenge anyone to explain to me how that is not the case. Excluding negative emissions, uncertain negative emissions, that we don't know how these will be achieved, if these can be achieved. The true scale of the challenge is about 15% per annum reductions on global average to limit warming to 1.5 degrees Celsius. And one question that I would pose to the audience is, how will it seriously be said that the government has had regard to climate justice, as the Climate Act requires, in making a new mitigation plan that implements the Programme for Government's 7% reduction? Second question, how even broadly is Ireland planning for the scale of negative emissions required? The IPCC talks a lot about bioenergy with carbon capture and storage. Where is our indigenous source of bioenergy? The peat-fired power station, coal-fired with biomass, was recently refused permission in Ireland on the basis that there is no adequate source of biomass indigenously, and that importing biomass from Australia and elsewhere would not be sustainable. And that's just to illustrate the 15% reduction. That's Carbon Brief's figure without negative emissions, 15% per annum to stay below 1.5 degrees. If the Programme for Government succeeds, Ireland's emissions will be about 46% down on 1990 levels by 2030. You'll see a lot of figures being bandied around. You'll hear talk of 51% over the next decade. It's really, really important in comparing efforts of countries to use the same baseline. The UNFCCC normally uses 1990. Ireland's emissions will be about 46% down. Consider that the UK achieved minus 40% by 2020. Ours rose by 10% over that period. The 46% reduction, if the Programme for Government is successful, falls short of the 50 to 55% reduction proposed by the European Commission, falls well short of the 65% that has been proposed by progressive MEPs in the European Parliament. And I want to finish on this note, looking to the future. The German government has been taken to court by a group of young people supported by Greenpeace and German Watch, alleging that German law's target of 55% emissions reduction by 2030 compared to 1990 infringes rights in German law as interpreted in light of the European Convention on Human Rights. In other words, there is ongoing international precedent for rights-based climate litigation attacking a target that is more ambitious than our own, and it's worth, I think, bearing that in mind. Overall then, governments can be and will be held accountable in court for their climate obligations. That's the message that Climate Case Ireland sends. It's also important to recognise that even had the case not been successful before the Supreme Court, the case had already had a major impact. Here's a quote from a leading environmental lawyer in Dublin. noting that the point of a case like this is never just winning or losing. It's already had lasting impact. I have no doubt, he said, that the case was chief among motives for urgent delivery by the government of the Climate Action Plan in 2019. So in other words, that action plan was in part a response to the proceedings. And that's an important feature of environmental litigation to bear in mind. Winning is ideal, of course, but movement building, changing, transforming the national context for policy and so on is equally important. In summary of what future mitigation plans are going to need to do, they're going to have to cover the entire period to 2050. They're going to have to be sufficiently detailed. Crucially, they're going to have to be credible, providing for political and legal accountability, because, and I want to emphasize this, it's impossible to achieve the national transition objective and realize rights whilst ignoring what the science tells us about the carbon budget and the emissions reductions that are needed in terms of short-term, the emissions reductions that are needed in the short term, as well as the medium and longer term. In addition to those kind of statutory points, future plans are potentially going to have to run the gauntlet of a climate case 2.0, raising rights-based arguments brought by an individual or individuals. And important there to keep an eye on two cases, the so-called Swiss Grannies case and the Galan Portuguese climate case, one or both of which may end up being heard by the European Court of Human Rights in Strasbourg before long. So if there is a climate case 2.0 in Ireland, that may rely in the future on a judgment of the European Court of Human Rights in the field of climate change. And my very final point is simply to say the value of these sorts of systemic climate judgments is cumulative. And whilst the Supreme Court in Ireland did not decide our case on the same basis as the Urgenda case was decided, the Urgenda judgment, I think, was really, really important in our proceedings. And there is this, I would argue, cumulative effect where other courts internationally look at what's happened elsewhere and say, well, look, the Supreme Court in the Netherlands has required more ambitious climate action. The Supreme Court in Ireland has quashed an unambitious mitigation plan and requires a new one. That sets a context for future judgments elsewhere. And really, I hope that the result from Ireland inspires others elsewhere, just as Urgenda inspired us. Thank you very much, and very happy to take any questions you may have. This is John Kenny, BL, and myself in front of a mural in Cork City that appeared a couple of years back in support of the case. Thank you.
Thank you so much, Andrew. That was fantastic and really interesting, and wonderful to get the detail there in terms of laying out the legal, the build-up and the way the case was constructed, and then the judgments in High Court and Supreme Court. Can I just say, first of all, a big thank you to you and to John Kenny and the other members of the legal team, and especially Tony Lowes, Clodagh Daly, and the other people who've run this very much on a voluntary basis with a great deal of hard work and commitment. And a lot of that is actually done by the legal team, who were very much in the background while the public facing campaigning side was done by others. But you did a mighty job, and thank you very much on all of our behalfs. And we're very proud in Stop Climate Chaos that Friends of the Irish Environment is a member of the coalition, and your expertise is extremely valuable, and it ripples right throughout the environmental movement. Which leads me to ask one question, which is that, Friends of the Irish Environment takes a lot of cases. It litigates on a lot of issues of public importance and of public interest. And yet it seems that it was impossible to make the legal argument that it could advance the rights-based arguments in the court case all along. And in contrast, even though presumably the Netherlands and Ireland are signatories to the same European Convention on Human Rights, the Urgenda case was successful in making those arguments. And the other feature about the Urgenda case that's different is, of course, that it was a class action. And we had one question that somebody popped into the Q&A box, which is why aren't we seeing class actions in Ireland around air pollution and other kind of serious environmental problems that affect people directly? Why is that kind of approach to litigation, not common. So those if you could address those two features and just explain maybe a little bit about the way that Friends of the Irish Environment works as a result to get around these obstacles.
Well, the first part of your question, maybe the easiest way into that is Urgenda and Friends of the Irish Environment and standing. Neither organisation would have had standing to take a case onwards to the European Court of Human Rights in Strasbourg. Okay. So that is clear, but that needn't necessarily lead to the same conclusion at the national level. In the Urgenda proceedings, the Supreme Court, there were different decisions on this point from the different levels of courts. In the Supreme Court, the Supreme Court said that Urgenda, on the basis of the Dutch Civil Code, had standing to bring the proceedings sort of on behalf of Dutch people, as it were. In our situation, as I mentioned, there had been a series of decisions in the High Court holding that Friends of the Irish Environment did have standing to litigate these sorts of rights issues. Then we have this judgment from the Supreme Court in the Mohan case in 2019, and then the Supreme Court says that Friends of the Irish Environment doesn't have standing in Climate Case Ireland. I think that, personally, I think that point is very finely balanced and could potentially have gone either way. But it went the way that it went. The Supreme Court said, you know, Friends of the Irish Environment doesn't have standing, an individual or individuals could have taken the case. We pointed out in the hearing, well, the question was, why didn't you just join an 18-year-old to the proceedings, who clearly would have had standing in terms of these personal rights? And we said, amongst other things, we said, look, the state's first response to this case when it launched in 2017 was to write back and say, a very aggressive approach on costs, saying you have exhibited way too much scientific evidence. We have had to spend a considerable amount of time preparing our reply to your affidavit, setting out the evidence. You have engaged in so-called prolix pleading. So you've pleaded too many arguments. And regardless of the outcome of the case, we're going to pursue Friends of the Irish Environment for the costs of our dealing with that affidavit. And so, as we said to the Supreme Court, look, if an 18-year-old had been joined to the case, how do you think that 18-year-old's parents would have responded on receiving that letter? You know, the very first thing that came back in response to the case. I mean, they would have been almost certainly terrified by that, at the potential financial implications of that. And it does, as I said, raise interesting questions under the Aarhus Convention, I think, in terms of prohibitive expense, its relationship to standing, and so on. In terms of the point about class actions, they're not provided for under Irish law. So that is that. An important thing to mention in the Urgenda cases, when it started, it was Urgenda plus about 900 individuals. But the 900 individuals fell away after the district court. So in the Court of Appeal and in the Supreme Court, it was all about Urgenda as an organisation. So there was a different conclusion on standing for Urgenda versus standing for Friends of the Irish Environment. And I don't want to take up too much time with one question, but I think there are certainly interesting questions about whether Friends of the Irish Environment could have been said to have standing as an exception to the general rule. For example, on the basis that, well, wouldn't Friends of the Irish Environment be best placed to litigate the rights of future generations? For example, who is the individual who is better placed to litigate the rights of future generations? Anyway, I'll leave that there maybe.
I love that answer. Just two other really interesting questions that are sort of connected. One is about sectoral mitigation plans. Now, bearing in mind that there will be some changes to the 2015 Act, and presumably there'll be some more detailed requirements for government departments to produce sectoral mitigation plans, will these be justiciable? I mean, obviously we don't know what the text in the law is going to be, but how specific will they have to be? you know, bearing in mind what the Supreme Court decided in the climate case. And the other question is slightly related in that it's from Jean Moore, who's asking if other countries, if there's an example somewhere of a country that's delivering a plan that's credible, sufficiently detailed, and providing for political and legal accountability, and at the level of ambition required for climate justice. So, in other words, is the threshold that the Supreme Court has set, is it realistic? Is it achievable? Is anybody doing it?
Well, the first part, the sectoral mitigation plans question, I probably can't really give an accurate answer to that, in the sense that, as you say, it will very much depend on what the legislation requires in respect of those sectoral mitigation plans. But I mean, my expectation would be that to the extent that they flow into the National Mitigation Plan, it would of course make sense that they ought to be sufficiently specific to deliver on the specificity required of the National Mitigation Plan itself. Or to put it another way, it would be pretty foolhardy to adopt a series of vague and aspirational sectoral mitigation plans. I don't think that would be well advised as an approach. And on the other question, in terms of international precedent, so the outcomes of Climate Case Ireland and the Urgenda litigation are quite different, in the sense that the Supreme Court in Climate Case Ireland quashed the plan on the basis they said, we're quashing the plan because it doesn't comply with the Act. You need to go away and make a new plan that does comply with the Act. In contrast, in the Urgenda case, the Supreme Court there said, you, the Dutch government, need to achieve at least 25% emissions reductions by 2020 compared to 1990. So they made a specific order with reference to a specific percentage that had to be achieved. And the Dutch government has gone about seeking to achieve that, to comply with the court's order. Urgenda fed into that process by producing itself about a 50-point plan for actions that could be taken to ramp up ambition and to meet the required ambition. But of course, each plan is context specific, country by country. But certainly there are international examples to look at. You know, look at what the Netherlands is doing in terms of electricity generation, closing new coal-fired power stations and so on. Look at how the UK has achieved its 40% reduction between 1990 and 2020. You know, there are all sorts of international examples of how do you go about deep decarbonisation. And hopefully those sorts of precedents are going to be looked at in delivering a new plan.
Thank you, Andrew. I just thought it might be interesting to go back to the rights issue for a moment. So the Supreme Court decided that the environmental rights couldn't be argued by Friends of the Irish Environment, but it did make an interesting reference to the possibility of a constitutional change as a sort of more, well, these aren't the words they use, but as a kind of more legitimate approach to introducing a new right into the Constitution. And I thought that was a very interesting point. We've had quite a few important constitutional changes in the past decade. We did have a constitutional convention in 2014. And interestingly, even though there were many submissions into that from environmentalists asking for environmental rights to be considered, the convention didn't consider environmental rights. It did, however, consider economic, social, and cultural rights and made a few recommendations around that. So I'm just wondering whether you think there's enough momentum after the climate case judgment to start campaigning for a constitutional referendum. Is that the best way we should use our energy? And if there were going to be some kind of environmental right or a referendum, what would the wording look like? Have you any thoughts on that? Because I'm mindful of a comment that Orla Kelleher, who wrote an interesting blog, and another activist with Climate Case Ireland about the judgment, made the point that greening existing rights, as in reading environmental rights into existing rights is a very weak strategy, and it isn't going to really reflect the kind of uncertainty around scientific and long-term impacts, tipping points, and the huge risks that go with ecological and climate breakdown can't really be captured in the sort of understanding we have of personal rights. So is it now the time to start thinking about introducing a new environmental right into the Constitution?
I certainly think that it is, and I'd recommend that that people go away and have a look at Orla's excellent blog post, which was published on EJIL Talks Today. And Orla makes the point that, you know, that the Supreme Court said that a right to an environment is, as I said, superfluous if it isn't broader than an existing right in the Constitution from which a right to an environment could be derived, such as the right to life. And you might think, well, how is that the case? Because couldn't a right to an environment involve more than the right to life of humans? You know, couldn't it engage rights of nature and so on? The right that was recognised in the High Court in the Dublin Airport case was phrased as a right to an environment consistent with human dignity. And as Orla points out, that is quintessentially an anthropocentric right. And therefore, the Supreme Court's conclusion is maybe not as surprising when you consider that. That is the way in which the right was conceived by the High Court, not as something, not as some broader rights of nature type environmental right and so on. And it's in that sense, I suppose, that maybe the suggestion, this idea that the future Citizens' Assembly on biodiversity might be an appropriate focal point or moment to look at a right to an environment, and maybe a broader understanding of a right to an environment in the context of biodiversity that isn't so anthropocentric. And yes, in 2014, as I recall, there was a lot of campaigning effort went into the right to an environment at that time, and it made it onto a long list, at least as I recall, and didn't make the final cut. And it was considered previously in 1996, around that time, and again at that time it was considered not appropriate to be taken forward. But now, you know, I suppose it's difficult to answer your question about is this a good use of campaigning time. You know, I tend to be of the view, let 1,000 flowers bloom, and to me this would be a good use of time for various reasons, not least because our Constitution is our foundational document, setting out, you know, this is who we are as a people, this is what we value, in addition to potentially playing an important role in law and policy development and so on. So I think that the Supreme Court, you know, kind of indicated a sort of lack of comfort with the concept, clearly, but also said, look, where this right has been recognized in many cases, as I said, it's been by way of a democratic process, not involving judges, but rather involving, you know, referenda and so on. So, you know, I think maybe we can take inspiration from that, looking to the Citizens' Assembly when it comes, and try to maybe ensure that this is on the agenda then.
Mm-hmm. Yeah, well, it's very exciting. We should think about that in future. And just following on from the point you just made about democratic engagement, John Russell had an interesting question about how the message and the result of the climate case can be best communicated to the public, which begs the question in a way of what is the message? What does it mean if you were to try to tell the public that this significant thing happened in Irish climate policy? What's the message? And how can we use that message to connect and motivate people to get involved in campaigning and talking to their public representatives and companies and other actors all around their environment?
Well, I think, as I said, I think the central message, like, listen, sweep away all of the detail. The central message of this case is that governments can be and will be held accountable for climate law obligations. you know, and that's true now and it's true in the future. And you know, there's a wave of climate litigation happening, and governments and others have to be cognizant of that, you know, when they are acting. So that, I think, is the central message to communicate. The purpose of the campaign that we built around the case was, I mean, one of the ideas behind it was to provide a focal point around which the climate movement could coalesce and build in Ireland. And it's in that sense that the case was branded as Climate Case Ireland very deliberately. You know, it's not branded as Friends of the Irish Environment versus Government of Ireland. It's Climate Case Ireland. It's a case that everyone can take ownership of. That was the idea. And I think that was successful, evidenced by the numbers, you know, who support the case, social media following, you know, but most importantly, evidenced by the public interest in the case. You know, the hundreds of people who turned out in the High Court, you know, the people who are kindly turning out tonight to listen to the webinar, and I hope that it's provided a moment of kind of hope and inspiration for the environmental movement, and from here we move forward.
Absolutely, it certainly has been that, and which begs the question about whether Friends of the Irish Environment has any future plans, and will there be a Climate Case 2.0 here in Ireland? And you know, what impact the judgment will have on other environmental law cases that are ongoing. And I know that you recently got a judgment today in relation to the Shannon LNG case, so perhaps you want to say something about that as well?
Sure, that's Fred Logue was the solicitor in that case, and John Kenny again, and James Devlin, you know, another amazing Friends of the Irish Environment case. You know, for such a small organization with such a small budget, they punch incredibly above their weight. We have another hearing in the Court of Justice in Luxembourg next week in a case to do with public access to litigation documents, and you know, just an incredible run of cases. I won't list them all off now, from peat extraction, legal aid, etc., etc. But so that, you know, the Shannon LNG case, I mean, I'm sure many listening are aware of the Shannon LNG project, challenged the extension of permission challenged by Friends of the Irish Environment in the High Court, questions of interpretation referred up to the European Court of Justice, the answer given today by the European Court of Justice, which passes back down to the High Court to be applied. And of course, it's necessary to wait for the High Court to apply that judgment, but it certainly looks like Friends of the Irish Environment will succeed in overturning that permission. And you know, the approach of taking systemic cases such as Climate Case Ireland and going after projects, you know, all of these things need to be done. But you know, Friends of the Irish Environment's ambition and drive and bravery and success rate is really incredible.
But do you see the next phase of litigation focusing on more project, or do you see an opportunity for more systemic or rights-based cases? I mean, a number of the participants here have been asking about economic and social rights and whether or not these can be advanced, you know, in litigation on the environment, and whether there's an opportunity to take cases on behalf of future generations of very young children. Do you see any opportunities on the horizon?
Well, so the Supreme Court, as I mentioned fleetingly in passing, the Supreme Court did give a bit of a steer in terms of, you know, left the door open to future rights-based challenges in environmental cases by an individual or individuals, and flagged up potential areas in the Constitution that might be relevant in the context of environmental claims. So, I mean, listen, it's almost inevitable that there will, or I would say it's probably inevitable that there will be rights-based environmental actions taken in Ireland in the future. as to Friends of the Irish Environment's role in those proceedings. The Supreme Court makes an interesting comment about a case being taken by an individual or individuals with an NGO offering whatever support it deems appropriate. I'm paraphrasing, but along those lines. But it seems pretty clear if there's to be a climate case 2.0, it would need to be brought by an individual or individuals. And that raises issues around prohibitive expense, and potential exposure if the case is unsuccessful and the government pursues an order for costs on a loser pays basis, and so on and so forth. But there are individuals willing to take environmental cases. You know, I'm sure we can all think of examples. Peter Sweeten being a very prominent example, who takes, again, lots of amazing cases and again, amazingly successful. So listen, I suspect, I think Kevin O'Sullivan, the Irish Times, said in his view it was only a matter of time before there is rights-based climate litigation, and I would share that view.
Great. I might just ask any of my colleagues, Oisín and Kate, if they have any further questions. I've tried to cover everything that came into the chat box that seems new, that you haven't touched on already, but Oisín, was there anything you wanted to highlight, especially around the climate law? Here he comes.
No, well, it's fascinating to hear Andrew describe the detail. I mean, it is very gratifying that a lot of we you know, Stop Climate Chaos campaigned for 8 years for the 2015 Act, and although we weren't satisfied with it at the end, we're glad it is what required the government to do any plan. I was convinced they weren't going to bother doing any plan before 2020 because they knew they weren't going to make the 2020 target. So they only had to do the plan at all because the law was passed. And then it transpired of the various grounds that FIE put forward in the case that the failure to comply with the weak 2015 law was the one that did for the plan. So it was really great to see the nail in the coffin of that National Mitigation Plan that Stop Climate Chaos had described as a moral and legal failure when it was published. But it's really fascinating to see, as Andrew's described, how the law, even with not a very strong law, has been so effectively used to hold the government to account. I mean, we've been trying to do that politically and through campaigning, but there's nothing quite like the clarity of a legal judgment to rock them on their heels, and particularly the way that the climate case combined that with campaigning, I think has given the whole climate movement in Ireland a shot in the arm. As we now turn our attention to a new government who have, you know, albeit inadequate still, more ambitious plans than ever before in climate change, and as we are determined to hold them to account and make them deliver for their promises, it's fantastic to see how successful the FIE case has been. And as we look towards now, you know, strengthening the 2015 law, making sure that we're even better positioned to hold government to account through politics, through campaigning, and through the courts in future.
Shall I say a word or two about the new Act, Sadhbh, or no? Because
Please do. Sorry, I was hoping you would. Thank you.
So I had in the interest of time, I moved this slide to the end, but I had one or two remarks. No, I suppose these are not consequences for the new Act arising from the judgment of the Supreme Court, but rather they're reflections on how the Act might be improved, having litigated the old Act, I suppose, if I bring them up. The first thing, and this is maybe a really obvious point, is to ensure, I think, that the Supreme Court's judgment is not undermined by whatever legislative changes are proposed. And the very obvious thing to watch for here will be any attempt to amend, remove, replace Section 4.2a of the Act, which was the basis for the victory, you know, the requirement to specify the manner in which the national transition objective would be achieved. Like, any attempt to do that, I think, would be a massive red flag. And, you know, and I'm sure everyone will be watching out for that. Secondly, I think it's important to try to find a way to put the Paris Agreement's highest possible ambition and climate justice at the heart of the Act. Because, you know, Ireland is supposed to take the lead. Ireland is supposed to act along with the other parties in a way that reflects its highest possible ambition. That is something which should evolve over time. The concept in the Paris Agreement is every 5 years there's a new national determined contribution. But I think ideally we should be looking for a climate act that provides for highest possible ambition to be reviewed more regularly than that. You know, on an annual basis, to be considering, is what we're doing, does this represent our highest possible ambition? If it doesn't, what can we be doing differently? What can we be doing better? There have to be, and others have made this point, there have to be safeguards, I think, to prevent or limit borrowing from future carbon budgets. Because, I mean, introducing carbon budgets will be totally worthless if the current government can simply plunder a future carbon budget. And as you'll know, the proposal that came out from Fine Gael in late 2019 provided for borrowing from future carbon budgets with no mention of safeguards. That the UK Climate Change Act 2008 contains, for example, a 1% limit on borrowing from the future. Again, that would be such a, you know, a red flag if there was an act that didn't provide a safeguard, because then the carbon budgets are just worthless. I think there ought to be a general obligation in the Act applying to every organ of the state, requiring organs of the state to perform their functions compatibly with the objectives of the UN Framework Convention and the aim of the Paris Agreement. And you can seek inspiration for that type of provision from the ECHR Act itself. That was one of the provisions that we litigated in Climate Case Ireland. Section 3.1 requires organs of the state to perform their functions compatibly with the ECHR, essentially. And equally, the second instrument I've mentioned there is Ireland's transposition of the Habitats Directive, which contains a similar general obligation on public bodies to exercise their functions compatibly with obligations under the Habitats and Birds Directives. So there are good precedents out there in Irish law for doing this kind of thing. That would be very meaningful. You know, it would form a, you know, you could make strong arguments under such a provision as to why executive action did or did not align with the UNFCCC and the Paris Agreement and so on. It would be a good thing to pursue, I think. Strengthening the have regard, this is a bit of a nerdier point, strengthening the have regard to obligations in the Act, because as many people were involved in campaigning for the 2015 Act, I know, and a lot of effort went into trying to have climate justice, the principle of climate justice, added to the list of things to which regard must be had when national mitigation plans are made. It would have been great had that have regard to obligation been stronger than have regard to, because it's quite weak. And there was some debate at the time of the passage of the 2015 Act around that, and it was narrowly defeated in the Shannon. But significantly this time, the heads of bill that Fine Gael proposed in 2019 has accepted the principle of obligations of the form shall be consistent with. So you mentioned, Sadhbh, that sectoral plans, there are also, as you know, new duties on local authorities. And while the obligations applying to central government are still of the form, they have to have regard to certain things when they make plans, where those matters have to be considered by local authorities have to ensure that their action shall be consistent with the same list of factors. So it's not possible now, at least this is the outgoing government, to object in principle that we can't do this. And that was the objection the last time was, well, some of these matters are mutually inconsistent potentially, so we can't require that bodies act consistently with all of them because that's not always possible. Well, we can point to the heads of bill from 2019 and say that principle is gone. You know, the horse is bolted on that argument. So certainly I think we should be looking to strengthen have regard to obligations to something of the form shall be consistent with. And then finally, Climate Action Council, many of these points have been made before. Independence has reared its head again because of the numbers, the proposed addition of a new ex officio member and the total number of members again raises this argument around, could the ex officio members form a majority? Gender equality on the Climate Action Council is so important. Only 2 of 11 members have been women since the foundation of the Climate Change Advisory Council. A greater range of expertise, I think like 8 of the 11 are primarily economists, look at improving the functions and crucially look at improved resourcing. So that was what I had to say about the Act for now.
Well, that mirrors much of or many of the recommendations that we made in a briefing we presented to the department some weeks ago. And actually, I don't have it easily to hand, but maybe if one of my colleagues can find a link to it on our website, we could pop it in the chat box as well. But I think they're really helpful summary of the minimum that we should expect from this new bill. Just before we wrap up, I just wanted to read one further comment from your colleague, but it has disappeared. No, it hasn't. John Kenny. He says, "It would be remiss not to credit Andrew's contribution," which I totally concur with. "Without Andrew and his ability to build a team and a movement, none of this would have happened. He was really the moving force behind bringing it in the first place and to keep it on course for 2 years." And I couldn't agree more, because an awful lot of the hard work of actually building the legal case, consulting with the lawyers, setting up the structures behind the scenes so that we could raise funds and that we could link in with funding organizations and whatever to get the bare bones of the campaign up and running. That was all done by you, Andrew. And we're all extremely grateful to you. But I also want to pay tribute to John himself, because the legal brains and the effort that goes into building these cases, it's highly professional and highly disciplined, and very high standards are expected and delivered all the time. And many of the lawyers that work for Friends of the Irish Environment never seek, personal credit for any of the cases. And, very often they don't always go our way, or if they do, it might take 2 years or more for it to get all the way through the courts, as it was in this case. So you have to be in it for the long haul, and you have to be committed. And yourself and John and the other legal experts behind the scenes, not to forget Tony Lowes, who's the force of nature behind the whole organization. But you really have done a tremendous job, and we're all very grateful to you. So I don't know if Anya or any of my colleagues want to come in and just begin wrapping up.
Yeah, so thank you so much to Andrew and Sadhbh. I think we all agree that was extremely interesting. And yes, thank you, Andrew, for all the work and the whole Friends of the Irish Environment team. And thank you to everyone who's attended. As you can see, every little bit of environmental action and every little campaign, as Andrew was saying, let 1,000 flowers bloom, whether you've just started and just got involved and have just come to this webinar to learn, or you've been doing climate activism for years and years. Thank you so much for everything that you do. And just to finish off, this webinar is the start of a new season of campaigning for Stop Climate Chaos, as I said at the start. And we're stepping up our campaigning for faster and fairer climate action. And we will be looking at this new stronger climate law and climate bill that Andrew was just talking about, and we'll have a webinar on that in the next 2 weeks. And we'll also be looking at things like how can we have more meaningful social dialogue, better public engagement to design climate policies that empower communities, create jobs, reduce inequality, as well as cutting pollution as fast as we can. So please stay tuned, sign up to our mailing list if you're not already there, keep an eye on our social media channels, and we will be kicking off hopefully a successful and ambitious autumn of climate campaigning. So thanks again to Andrew and Sadhbh, and thank you everyone for attending, and have a lovely evening.
Thank you very much, Andrew.
Well, thanks everyone. Thanks for listening, everyone.
See you in a couple of weeks.